أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على سيدنا محمد وآله الطيبين الطاهرين اللهم صل على محمد وآل محمد. Respected brothers and sisters, Assalamu alaikum wa rahmatullahi wa barakatuh. We continue our discussion on Islamic guidelines for transactions. Previously, we discussed some very important conditions when it comes to the aqd, and the aqd is a contract or a transaction between two or more parties. There is one very important rule or law that scholars have discussed in Fiqh al-Mu'amalat, in the laws of transactions, which the author discusses on page 47 of our book. If you don't have the book, we have the books here available for you. So on page 47, under the heading Al-Maqbūḍu bil-Aqd al-Facet, the author discusses this very important law. Let's break down this law and try to better understand its application. There are a few key words in this law that we should be familiar with. And the rule is called as such. مَا يُضْمَنْ بِصَحِيحِهِ يُضْمَنْ بِفَاسِدِهِ. Let's look at these terms here. They are simple terms, and by knowing the terms, we'll understand this qa'ida or this law. Ma yudhman. Yudhman comes from the word daman. What does yudhman mean?
Something that's guaranteed.
Something that's guaranteed, something that you're liable for. Daman in Arabic means guarantee. Or we can also use the word daman to refer to liability. Ma yudhman bisahihihi. What does sahih mean? Right, correct, valid. Something that is valid, something that is correct, something that is right, we call it sahihihi. Yudhman bifasidihi. That which you are liable for when it is valid, you are liable for it when it is facet. And what does facet mean? It's the opposite of sahih. So if sahih means valid, validity, what does facet mean? Invalid. Now facet has a number of meanings in Arabic. One meaning is corrupt. The person who's corrupt, morally corrupt, we call them facet. But you can also use the word and refer to natural things. For instance, if the food rots, you can say in Arabic, facet. It's no longer suitable for eating. One of the meanings of facet in transactions is what? Invalid. So now, let's translate the sentence and then see how scholars apply it. That which you're liable for when it is a valid transaction, you're also liable for it when it is an invalid transaction. Think about this statement here. What does it mean? So on this page, the author states that scholars, after they discuss the conditions for the contract, for the aqd, they usually talk about the following. فَإِنَّ الْفُقَهَاءَ تَكَلَّمُوا عَنْ حُكْمِ الْمَقْبُوضِ بِالْعَقْدِ الْفَاسِدِ. If I engage in a transaction, in a contract, and the transaction turns out to be invalid, scholars have said what the consequences are. And this is the title of the qa'ida of the law. قَاعِدَةٌ مَا يُضْمَنْ بِصَحِيحِهِ يُضْمَنْ بِفَاسِدِهِ. So what does this qa'ida mean? The author says that the aqd as-sahih, the valid transaction, is the one that fulfills the conditions. All the conditions are valid. The verbal transaction is valid, or the non-verbal transaction is valid. Those who are engaging in the transaction, they're authorized to engage in this transaction. They have fulfilled all the Islamic requirements for that transaction. They're not engaging in anything haram, for instance. When all the shurut, the conditions are met, what do we call this? Aqdun sahih. It's a valid transaction. Now, one of the consequences of a valid transaction is that when the transaction is done, that which is in your possession from this transaction, you're liable for it. You bought a book. You paid $20, and in return, what did you get from the seller? A book. Now that the transaction is valid and it's all done with, the book is in your hands. Legally, you're liable for it. What do they mean by legally you're liable for it? Let's say that book got destroyed. You were walking back home from the shop, from the bookshop, and basically the book fell into the river. So you lost the value of the book, you lost the book. Can you go to the bookshop and tell him, hey, give me my money back? I don't have the book anymore in my possession. Can you do that legally, Islamically? Even in our public law? No. Why not? You could tell the seller, I lost the book. I don't have a book in my hand, in my possession anymore. Give me back my money. What will the seller tell you? No, it's none of my business. You lost it. Even if it wasn't your fault. Let's say the poor guy's going back home, a storm comes, and the storm destroys the book. The seller will tell you, I gave you the book in good condition. You left my shop. On your way home, whatever happens, I'm not liable for. Who's liable for? You. Who incurs the loss? You do. So the buyer here, the customer, has no right to go and tell the seller, compensate me. Give me back my money. He says, no. We have a valid transaction here. Now that it was in your possession, you're liable for it. Let's look at the opposite scenario. You gave the seller $10. The seller took the $10 to deposit it in the bank. On the way, it got lost. Can he come back and tell you, hey, I don't have my $10 anymore. Give me back my book. No, too bad. You incur the loss. You're liable for the loss. This is the meaning of dhaman. Dhaman means when you're liable. And one of the consequences of liability is that if it gets destroyed, you lose it. Who incurs the loss? You. So does this part make sense? Is it clear? Okay. Now let's get to the qa'ida, the law that scholars here are discussing. Scholars are saying, if the aqd was sahih, and you would be liable for it, then if it happens so that the contract is not valid, one of the conditions of the contract was not fulfilled, one of those conditions were not fulfilled, you're still liable if something like that were to happen. Let me give you an example. Let's say you go to a gold shop or a grocery store that sells grains. We have a qa'ida, inshallah we'll talk about this in the book of interest or riba or usury. We have an Islamic law that states, if you are engaging in the following transaction, kali bil kali. What does kali mean? Those products that are exchanged in terms of their weight. Sometimes you buy something, it doesn't have to do anything with its weight. You are buying a desk. I don't care what the weight is. Or sometimes you'll buy some fruits based on the quantity. Sometimes you will buy a fruit based on a quantity. Have you seen? Sometimes they'll make a sale. Each watermelon is $2. It doesn't matter whether the watermelon is 3 pounds or 4 pounds, right? Or sometimes you buy apples not in weight. You buy them in quantity, right? This is called ma'dood. We're not talking about that. We're talking about those products that you exchange in terms of weight. What are some examples today in the market? Something that you buy based on the weight. Fruits, vegetables, grains, right? Let's say you buy seeds, wheat. It's all by the weight. This is called kali bil kali. It's wazn. It's a type of weight. In Islamic law, if you are exchanging something that's sold by weight, if you are exchanging it with another thing that's sold by weight, you have to keep the same exact quantity. And you have to keep the quality. If there is a difference in that quantity, it becomes riba. So here's an example. You have wheat in your house, wheat. Somebody donated to you wheat, hunta. Now the quality of that wheat is not good. So you go to the grocery store and you tell them, look, I've got 10 pounds of average quality wheat. You have superb quality wheat. I'll give you 10 pounds of average quality wheat in return for 5 pounds excellent quality wheat. See, the quantity changed now. You're giving 10 pounds in return for how many pounds? 5. But what's the difference? The quality you're giving is adi, it's just normal quality or bad quality. But the quality you're getting from the grocer is what? Good quality. Is this an acceptable Islamic transaction? No, this is riba. Maybe you're not aware of this, but this is a type of riba. Same thing with gold. You go to a jewelry shop, you tell him, here, I've got something that's 100 grams of gold, it's 18 karat. Give me something that's 50 grams, less in weight, but 21 karat. Haram. This is riba. This is one type of riba. Islam has outlawed a transaction like that.
How do you judge quality?
Well, basically, I'm just mentioning the incentive for why a person would do that. The point is, the guy gave 10 pounds of wheat, he's getting 5 in return. This is haram. Now the person, if you ask him, why are you doing that? He says, well, I want the better quality. Yes, what you can do, a workaround that's halal, the 10 pounds of bad quality wheat that you have, sell it. Sell it for $10. Get the $10. With those $10, buy those 5 pounds of, that's fine, that's not riba. But directly, if you give the wheat in return for wheat, less in weight, haram. This is riba. Kali bil kali. Now you could ask, what's the philosophy behind this? We can talk about that in the book of riba. Why did Islam outlaw this type of transaction? Because if you look at past historical societies, basically this was a way to take advantage of the poor. That's not the point of discussion now. So let's say you didn't know. You went to the grocery store, you gave 10 pounds of wheat, in return how much did you get? 5 pounds. On your way home, you understand that this aqd is what? Sahih or Facet? It's a Facet aqd. Okay. Now on your way home and you're carrying that good quality wheat and you're excited about it, the storm comes in our example and it throws it into the river. There's a heavy gust of wind, it throws it in the river. Who's liable for this loss? Who incurs this loss? You or the grocery store?
You.
Someone could argue, right, using some good falsafa here, someone could argue, hey, this is an invalid transaction. That wheat is not even mine. That 5 pound good quality wheat is not even mine. I have to give it back to the store owner. And I have to take back the 10 pounds that I gave. Because when Islam says a transaction is not valid, what do you have to do? Return it. Take it back and get back the money that you paid or the product that you exchanged it for, right? So the person, the customer could say, Yallah, this is in my favor. I discovered that this is riba, and so the mu'amala is fasida, the transaction is not valid. So the wheat that I have, the 5 pounds good wheat, the wheat that I have here, in reality, who do I have to give it back to? The store owner. And what do I take from him? The 10 pounds, my own wheat that I gave him. So if that good wheat got thrown into the river because of a storm, you could argue you lost, the store owner, because it's not even mine. Yallah, give me back my wheat. Is this valid? No. Why? Because of this qa'ida. Because of this rule. This rule says, imagine the act was sahih, and it was a valid transaction, and the wheat that's in your hand got thrown into the river because of the storm. Who would have lost it? Whose loss was it? You or the store owner? No, if it was a sahih transaction. Imagine if it was a sahih transaction. You got the wheat that you wanted. You left the store. On your way home, the product got damaged. It's your loss. This qa'ida says, if it was a valid transaction, sahih transaction, and you would be the one who's liable for the loss, if the transaction is invalid, you're still liable for that loss, not the store owner. So, this is what Islam would tell this person. Islam would tell him, you did a rabawi transaction, an interest-based transaction. So, here's what you have to do. The 10 pounds you gave to the store, go claim it, it's yours. The 5 pounds that you got from the store, go give it back. What are you going to say? I don't have it, it's in the river. What does Islam tell you? Pay the value. Go get another 5 pounds that's exactly like it, give it to him, or give him the value in some cases. Where it's not by weight, give him the value. It's worth $10, give him $10. So you lost, not the store owner. This is the qa'ida. Basically, this is the law. Any questions about this law?
So yesterday I was at Kohl's and this lady out of nowhere came up to me. She had a gift card for $75. And my transaction was more. And she's like, please, I beg you, can you give me cash and take it? She goes, just give me 55. Is that riba?
So you gave her $55 and in return she gave you a $75 gift card.
Yeah.
No, that's not riba. Why? Because it's not something by weight. That's number one. Number two, it's not a loan that causes interest. You're just basically buying that gift card for $50.
Yeah.
That's not riba. That's a valid Islamic transaction. That's fine. You can do that. In fact, money exchangers, right? Those who exchange money with currency. Let's say there's British pounds. And you're desperate for some British pounds, you need to go to Britain. So 1,000 US dollars is equivalent to 800 British pounds. There's a person, he says, give me $1,000, I'll only give you 500 British pounds. It's not haram. Yes, morally it's wrong to take advantage of people. There are some instances when it's haram, but this is not a rabawi transaction. That's not interest. That's fine.
But what if you argue that the quality of that gift card is much higher than the $50?
They're not of the same level. See, al-kali bil-kali, that means the product is of the same, it's the same thing, right? It's wheat and wheat. However, what you did, you gave cash $50 in return for a gift card. That's different. That's fine.
So if it was a gift card for a gift card, it would have been a...
Well, no, because gift cards, you don't sell them by weight. The condition is if it's a thing that's sold by weight. If it doesn't fall under that category, that's fine. Yes.
So that if we have an example of houses, for example, and one of them is larger in size and two others, like the other party, they're selling two houses.
That's a good example. There's a large house the value of it is $500,000, let's say. And then there's two smaller houses, each one is about $250,000, let's say. So you make this deal. You tell the owner of the big house, give me your big house, let's do this transaction. Sell me your big house in return for these two small houses that I give you. Is that riba? No, why not? Because houses are not sold by weight. It's not called a makil. It's not kail bil kail. So it's not riba. You can do that. In fact, money. You could sell money for a greater amount. For instance, you can sell money. You can tell a person, I sell you $1,000 in exchange for $1,500 next month. You could do that. And the Arabs objected to Islam. قالوا إنما البيع مثل الربا. What's different about this than riba, than a loan? The Quran says there's a difference. Allah has made riba haram, وأحل الله البيع وحرم الربا. We'll talk about that inshallah in the book of riba. This could cause some confusion as to why Islam would do that. So to summarize, my dear brothers and sisters, this qa'idah, this law, it says whenever you have a valid sahih transaction, and you are the one who has to be liable for the loss, it's your loss. If it turns out to be that the transaction is not valid because one of the conditions were not fulfilled, it's still your loss. It doesn't change anything from that aspect. So any questions on that? I'll mention one other example so we can make this idea clearer. So we mentioned the book example. Let's mention another example. You buy a laptop. You go to a store, you buy a laptop for $1,000. You pay the money. Here's $1,000 in return for a laptop with these specifications. You take the laptop, you leave the store. You're on your way home. When your car bumps into something, crashes, the laptop goes flying out the window, falls on the ground, it's shattered. A bus comes and smashes it. Whose loss is it? Yours. Can you go back to the store and tell him, give me back my $1,000? Hey, my laptop is destroyed. It's like, no, sorry. It's not my fault. If I had given you a defective laptop, sure, bring it back to me, we can replace it. But the fact that it got destroyed in an accident, that's not my business. So it's your loss, صح? Because it's a valid transaction. Now imagine if the transaction was invalid. Now there are many types of invalid transactions. We just gave one example. And the example that we gave is the one that causes riba, usury in Islamic law. So here's the example I'll give you. You have a necklace, it's 300 grams. That's a pretty heavy necklace, yeah? 300 grams, and it's 18 karat gold. What's the value of such a necklace? Just give me an idea. يعني. Okay, let's say $1,000. You want a better necklace with better quality gold, okay? So you go to the jewelry shop and you tell him, I have a necklace, the weight of it is 300 grams, it's 18 karat gold. I see you have a really nice necklace. It's less in weight, it's 200 grams, but it's 21 karat gold. And I really want the 21 karat gold. I don't want the 18 karat gold. So here, take my necklace, I sell my necklace to you, and I buy your necklace. We're exchanging a necklace for a necklace. In Islamic law, is this halal? No. Why not? Because gold is being exchanged based on what? Weight. Because it's being exchanged by weight, it's haram. You can't do that. This is riba. Okay. Let's say you didn't know or you didn't care. You're like, I'm going to get that necklace. So you took the 21 karat necklace. On your way home, what happens? It gets thrown in the river. That's it. It's lost. It's gone. Whose loss is it? Yours. Why? Because of this law. If we did not have this law, it would be the jewelry store's loss. Why? Because it's an invalid transaction. So what does Islam tell you when it's an invalid transaction? Islam tells you, look, this necklace, the 21 karat gold necklace, it's not yours. Because this transaction is void. Give it back to the store owner and claim back your 18 karat gold necklace. So now the person can say, okay, now that the necklace got thrown into the river, it's his loss. It's his necklace. I had to return it to him anyway. Islam told me, hey, it's not yours. Give it back to him. So I'll go to him. I'll tell him, give me back my necklace. He'll tell me why. I'll tell him because Islam says this transaction, batil, it's void. So give me back my necklace. He's like, okay, here's your necklace. Give me back my necklace. The person can tell him, sorry, it's in the river. A storm came. It's not even my problem. A storm came and threw it into the river. Islam says, according to our legal law, no. Give him the value of that necklace. Or go and replace it with another similar necklace, 21 carats, 200 grams. Why? Because of this law. It's true that the transaction is not valid, but had it been a valid transaction, it was your loss, not the store owner's loss. So now that it's an invalid transaction, it's still your loss, not the store owner's loss. That's all the qa'idah says. Very simple. Any questions about it? Does it make sense or no? Okay. So now, this is one thing that the author mentions. Let's go to page 49. The author mentions the opposite scenario of this qa'idah. Yes.
You did purchase it with money though, the gold, even though it was...
No, in this example, there's no money involved. You gave a necklace for a necklace.
You're talking about the exchange, right?
No, I'm talking about, see, if you paid money, money is fine. There's no riba with money.
You paid money for the weight of the gold though. Like 300 grams, you paid money to get that.
There was no money involved in this transaction. What I did, I went to the jewelry shop. I told him I have a necklace. It's 300 grams, 18 carats. Here, I'm selling it to you for the 200 grams, 18 karat gold. There's no money. If there was money involved and you sold, ma fi riba. For instance, you go to the jewelry shop store, you tell him, here, buy this necklace from me. How much? $1,000. Okay, give me $1,000. Then I use that cash, I'll buy the other necklace that's higher in quality. That's fine. Because now these are two separate transactions. We're talking about one transaction, no money currency is involved. You're just exchanging the necklace for a necklace. But the difference is, one of them has higher quality, one of them has higher quantity. You can't do that. In Islamic law, that's riba. Okay. So, now on page 49, the author talks about aks al-qa'ida, the opposite ruling. If in a sahih transaction you were not liable, then if it happens to be an invalid transaction, you're not liable either. And this is called the opposite. مَا لَا يُضْمَنْ بِصَحِيحِهِ لَا يُضْمَنْ بِفَاسِدِهِ. That which you're not liable when it's a correct transaction, you're not liable when it's an incorrect transaction. I'll just give you an example, it becomes very clear. Hiba, gift in Islam, is a transaction. Somebody gives you a gift. Here, I give you a laptop as a gift. You have to accept in order for you to own it, right? You have to accept. So if a person says, no, I don't want it, does it become automatically yours? No, of course not. Okay. So now let's say the person gave you that laptop as a gift. You took it home. On the way, it got destroyed. You lost the gift. The storm threw it in the river. Whose loss is it?
Yours.
Why is it your loss? You didn't lose anything. Somebody gave you a gift, the gift got destroyed. What did you lose from your own ownership? Do you say that day I lost? No. not mine. It wasn't mine. I got it for free. Somebody gave it to me as a gift. It got destroyed. ما خسرت شيء.
But it is.
Yeah, it became yours, but you didn't lose.
Right.
You didn't lose anything. It's his property given to you freely as a gift, got destroyed. So technically, you didn't lose anything. You just didn't get it. You did not get that gift. That gift didn't continue with you. Okay. Now, if the person, after giving you the gift, and the gift got destroyed in the river, if the person comes and he says, you know what, I changed my mind. Give me back my gift. Are you liable to give him back that laptop or the value of the laptop? No, you're not liable. You gave it to me as a gift. I'm not liable for anything. It's your loss. It's not mine.
That could be a common thing that would happen.
That could happen, yes. That's a very common thing. Somebody gives you a gift willingly, no pressure. They really gave you a gift. You use the gift. They come back and they tell you, you know what, give it back to me. Are you required by Islamic law to give it back? No. That's it. It got lost in the river. Sorry. Rah. Okay. Now, let's examine the opposite scenario here. If a person gives to you a gift, you use that gift or it gets destroyed. Later you discover this transaction of gifting you was invalid in Islamic law. It was not a correct method of giving a gift. One of the conditions were not fulfilled. So the gifter, the one who gave you the gift, he comes and he says, look, I know I gifted this to you, but I discovered Islamically this was not valid. So give me back the gift. What can you say to him? Sorry, it's your loss. It's not my loss. Because if it was a sahih gift, it wasn't my loss if it got destroyed. I don't have to be liable for anything. So now that it's an invalid gift, it's your responsibility. It's not my responsibility.
It's still the person who gave the gift's responsibility.
Yeah, it's the person who gave me the gift. I told him that's your problem. It's not my problem. Is this clear? So this is what the author means on page 49 when he says, "Ma la yudman bisahihi, la yudman bifaside." When it's a valid transaction, you're not liable. There's no consequences for you. In this case, there's no consequences for you if it turned out to be a gift that's not valid.
Just out of curiosity, if they do give you a gift that's invalid and they have to get it back and nothing happened to that gift, you have to give the gift back?
There are conditions. We'll talk about them in the book of gifts. There's a lot of details. Is the person your rahim or no? For instance, if you give a gift to a person who's a relative, blood relative, you cannot take it back. Even if it's in their hands, they've not used it, it's brand new, untouched. But if it's a friend, in certain cases you can. If the person has not used it, right, you can take it back. You gave a laptop to a friend. He has not touched it yet, it's not used. Before he uses it, you call him, he's like, you know what, I changed my mind. In certain conditions, you can claim it back. But let's say the person used it. You gave a person food as a gift. The person has not eaten it yet. Can you claim it back as the gifter? In a lot of cases, you can. Yes. Let's say right now, I give you food. I put an apple before you. Here's a gift. You have not eaten it yet. Can I say, you know what, I changed my mind. Give me it back. Can I do that? Yes, you can do that in a lot of cases. There are conditions where you cannot. One of them is the person ate it. I gave the apple to Ali, he ate the apple, and then I tell him, you know what, I changed my mind. Give it back to me. He says, but I ate it. Give me the money of it. No, you can't do that. Khalas, it's gone. Or if Ali is my blood relative, let's say I give that apple to Ali and Ali is my brother, my cousin. And then I tell him I changed my mind. He still has not eaten the apple. Can I claim it from him? No. If it's a rahim, I cannot claim it back. So we'll talk about these rulings in the book of gifts.
So are the in-laws considered a blood relative?
No, in-laws are not blood relatives. Blood relatives are those whom you share a grandparent with.
Okay.
like your uncles, aunts, cousins, you go back to, do you know what the meaning of rahim is? You probably will be surprised. What's rahim? Uterus. Womb. Other word, and it's another word for womb. Rahim in Arabic is called rahim because basically in the near distant grandparents, you shared a womb. That means you had a shared grandmother. That's what it means. Now, obviously, we don't think of that meaning when we say rahim. It just means a blood relative. So in-laws, no, your mother-in-law is not your blood relative. She's not related to you by blood. She's related to you now through marriage, but not blood. So no, in-laws are not considered blood relatives. Blood relatives are your basically parents, grandparents, uncles, aunts, great uncles, great aunts, cousins, nephew, niece. These are the blood relatives.
We're discussing that in family law.
In family law, yes, that will be discussed inshallah, the details of who is a blood relative, because it's not that set in stone. Different scholars may have different specifications of who's a rahim. So on page 49, basically the author is saying that if the wahib, the one who's giving you the gift, gave you a gift, you use that gift, and then it turned out to be an invalid transaction. The act of gifting was not even valid to begin with. That's it. The loss is on him, it's not on you. You're not liable for that. So this is the قاعدة ما يضمن بصحيحه يضمن بفاسده ما لا يضمن بصحيحه لا يضمن بفاسده. Is that clear? I did my best to, explain this in simple English terms. I know this is technical Islamic law. It could be difficult. But this is the gist of this قاعدة. Is it clear at its core? Okay. Any questions about it from our online members? Any question? Does this قاعدة make sense to you? Or have I confused you this evening? Any responses from our online audience? Okay. No, alhamdulillah, it makes sense. Okay. Alhamdulillah. Fiqh can get very technical, but it's beautiful when you look at the details and you really appreciate what the maraja have to go through. I'm just giving you the tip of the iceberg here. Maraja will go months just discussing what I just said in 30 minutes. It's very detailed. And it has a lot of consequences in Islamic law. This happens a lot, where people do transactions, it turns out to be invalid. So what's going on here when it comes to an invalid transaction? Okay. On page 50, the author discusses the proof. Everything that I said, right, in the last half an hour, what's the proof for this in Islamic law? Where did the ulama come up with this qa'ida? Where did they get this law from? The author says we have 5 pieces of evidence that we can cite to prove this qa'ida. That if you did a transaction and it's valid, it got destroyed in your hand, the product, it's your loss. So if it was an invalid transaction, it's whose loss? It's still your loss. Okay. He says, وَاسْتَدَلَّ الْفُقَهَاءُ عَلَى قَاعِدَةِ مَا يُضْمَنْ بِأَدِلَّةِ. The scholars have given the following evidence for this قاعدة. مَا يُضْمَنْ بِصَحِيحِهِ يُضْمَنْ بِفَاسِدِهِ. أولا, he says that when there is a transaction that's not valid, the product and the price goes back to its original owner. So in our example, you bought a laptop from Best Buy. The laptop is in your possession. It got destroyed because of the storm, in our example. Then you discovered that the transaction was not valid. For whatever reason, it did not meet one of the Islamic conditions. The example that we gave was the riba one, right? Okay. So now that you discovered the transaction is not valid, what happens to the laptop and what happens to the $1,000 that you paid at Best Buy? What happens? What happens to them? What's the consequence of an invalid transaction? See, if it's a valid transaction, the laptop is who? Who does it belong to? You, the customer. And who owns the $1,000? Best Buy, right? If the transaction is invalid, what happens to the $1,000? No, we're not talking about loss right now. We're just talking about you discovered that the transaction is invalid. What happens when it's an invalid transaction? You live in an Islamic society, your marji' tells you, you buying that laptop, haram. Islam does not approve of that because X condition was not fulfilled. So what do you have to do then? Just sit home and enjoy the laptop? You return the laptop to Best Buy and you claim what? Your $1,000. You tell Best Buy, look, this transaction we did today was invalid. So when something is invalid, everything goes back to its owner. The $1,000 go back to me. The laptop goes back to you, Best Buy. Okay, is this clear? Now in our example, what happened to the laptop? Got thrown into the river. So when you go to Best Buy is going to do what to you? Because it was an invalid transaction. What are they going to do? Best Buy. They have to give you the $1,000. In return, what do you have to give Best Buy? Originally, what do you have to give them? The laptop. But where's the laptop? The laptop is in the river. So whose loss is this? Your loss. You're liable. So what do you have to give Best Buy? Give them the money, the value. If there's an exact laptop that looks like it, perfect specifications, brand new, give it to them. Here. I lost that laptop, here's a duplicate of that laptop. Or here's the money. So technically I lost $1,000, right? So this first piece of evidence says that is the default. Because the laptop you discovered is not yours. It's Best Buy's because of an invalid transaction. So you have to give Best Buy the what? The laptop. Now you could say, but I don't have it. Okay, compensate them. See, we don't even need a hadith to tell us about this qa'idah. It's just by default. Because when it's an invalid transaction, everything, the price and the product, they go back to its original owner. So I have to give the laptop back. I don't have it because the storm threw it in the river. Okay, I have to give the value. This is the first piece of evidence. Is this first piece of evidence clear? Okay. The second piece of evidence, the scholar says, the author, ijma'. What does ijma' mean? Consensus. The consensus of scholars is that this qa'idah is valid. When the laptop got thrown into the river, it's your loss, not the loss of Best Buy. It's your loss. There's ijma', there's consensus on this issue. Number 3, there is a hadith that states from the Prophet sallallahu alaihi wasallam. It's a very popular hadith. على اليد ما أخذت حتى تؤدي. What does على اليد ما أخذت حتى تؤدي mean? Let's write this on the board because this is a hadith you'll hear very frequently in Islamic law in the book of transactions. على اليد ما أخذت على اليد ما أخذت حتى تؤدي. Look at this law here. Ala in Arabic means what? On. It can also mean against. Right? I have a right on you. That means against you. Yad means what? Hand. Ma akhadat, that which it took. Hatta tuaddi, until it fulfills it. Basically, this qa'idah means if you took something, right? You're liable for it until you take it back. I take something from you. You left the class, I took your book. And I'm reading it without your permission, let's say. My bad luck, during those 5 minutes that I'm reading your book got thrown into the river. Whose loss is it here? Your loss, the owner of the book, or me, in whose hands the book was?
Yeah.
Me. It's my loss. What's the proof? This hadith. This hadith says when you take something, it's in your possession, you're liable, it's on you, until you give it back. Once I give it back to you, then it's no longer my liability. Okay, let's apply it to our scenario. When I took this laptop from Best Buy, whose liability was it? It's my liability, it's in my hands. Remember, it's not a valid transaction, so who really owns the laptop? Even though I paid $1,000 for it, but because it's an invalid transaction, who really owns the laptop? Best Buy, it's theirs, and it's in my hands. And when it got destroyed, it was in whose hands? In my hand. So this hadith says, it's on you, against you, until you give the laptop back to Best Buy. Well, I'm going to say the laptop is gone. So what does Islam tell me? Give the value of it. So this is another proof for this qa'ida. Ma yudhman bi sahihah. This hadith from the Prophet sallallahu alaihi wa alihi. Is that clear how we applied this hadith? Okay.
So, is that the same thing how you go some places and somebody tells you, oh, could you look over my stuff? And then like you are just busy on your own thing and suddenly they come back and their stuff is not there.
That's a good question. There is one exception to this qa'ida, to this law that the Prophet says. If you were entrusted by the owner and you were not negligent, it's not on you. Let's say someone gave you as an amana, look over my stuff. You were negligent, you didn't care. It's in your possession now, but you didn't care. You let it get destroyed, or you let it get stolen out of pure negligence. Or you were mishandling it. You were being clumsy and you mishandled it and you broke it. Somebody says, here, keep my iPhone in your hands for an hour, I'll be back in an hour. You're just clumsily throwing it in the air, fidgeting with it, it got thrown in the river. If it's out of negligence, who's liable for it? You. But let's say it was not out of negligence. You were holding it and guarding it with your life. This storm comes and just throws you on the phone in the river, and the river gets, and the phone gets drowned in the river. It was not your fault. In that case, whose loss is it? The person. It's not my fault. I was not negligent. That's an exception. So we're not talking about that scenario. If you were not negligent, you were responsible, that's fine. Or when you borrow things. Let's say you borrow something from someone, right? I borrow this from you for a month. And you were negligent with it. You broke it deliberately or out of negligence. You have to compensate the person. But yes, if the thing broke down, not because of your negligence, on itself it broke down, or it was discovered that it had a prior issue, it's not on you. Let's say you rent a car and you're still in the parking lot at Avis or Budget or Hertz. I think Hertz is going bankrupt these days. They're selling a lot of cars. You're in the parking lot, you're pulling up the booth, the window, the engine burns. You didn't do anything. Is that your fault? No, it's not my fault. Yeah, the car was in my possession, but I didn't cause the damage. They lose that damage. Okay. So this is the third piece of evidence. And then the author mentions number 4 and number 5. Basically, it's a similar argument. No need to go into them now. You could read them on your own if you like on page 50. They are just other proofs for this qa'ida, but I think that would suffice for now. Okay. Another interesting point over here. In Islamic law, in the book of transactions, we have two things. We have ayn and we have manfa'a. Ayn means the product itself. Manfa'a means the usage of it. Apply these two terms to a car. What's the ayn and what's the manfa'a? The ayn is what?
Can you translate ayn again?
Ayn is the essence of something. It's the product itself. Manfa'a is the usage of it, the benefit of it. So what's the ayn here? The car itself, the body, the metal. What's the manfa'a? Using it, driving it. Okay. If you're renting a house, what's the ayn? The house itself. What's the manfa'a? Using the house. And there's types of manafa' too. You have a sheep or a cow and milk. What's the ayn here? If you borrow a cow or you rent a cow, what's the ayn here? The animal itself. What's the manfa'a? The milk that's coming from it. Okay, so you see the distinction between ayn and manfa'a. Now, if that product which you bought from Best Buy that got destroyed, if it also had a manfa'a, it had a usage that has value in society. Like what? Give me an example. Let's say if you wanted to rent a laptop for a day. Do they do that anywhere? Can you rent a laptop for like a week? There's no place that rents you a laptop?
Maybe like the library.
Library, okay. Let's suppose you live somewhere where they rent laptops, $10 a day. Is that too much? $5 a day. طيب. $5 a day, they rent a laptop. So what's the average benefit of this type of laptop? $5. Got it? Okay. You took this laptop from who? From Best Buy. Thinking that it is a correct transaction. Well, it turned out to be an incorrect transaction. There's riba or some other condition was not fulfilled. So you got this laptop from Chicago. In Best Buy, they were making a great deal on Black Friday. You went and you got a laptop. Now you're driving to Michigan. Some storm caused the laptop to be destroyed. Okay. Now, you need another 2 days to go back to Chicago. You got the laptop on January 1. January 2, January 3, 3 days later, or January 4, you're back in Chicago giving Best Buy the value of it. Because you tell Best Buy, this is not a correct transaction, so give me back my money. Now I have to compensate you for the laptop. Okay. So the laptop is worth how much? $1,000. That's the ayn that's worth $1,000, the laptop itself. And we assume that renting a laptop, using a laptop costs how many dollars per day? In our example, $5. What else do you need to give Best Buy in addition to the value of the laptop? What else do you need to give them? For those 3 days, what else do you need to compensate them? $15. So in reality, you tell Best Buy, okay, the $1,000, give it back to me here. Let's keep it. That's yours. I have to give you an additional $15. Why? Because this laptop has a usage and it has a value. And because the transaction was not valid, these 3 days, who's the owner of the laptop really? No, it's not a valid transaction. It's riba. Islam does not consider this your laptop. Give it back to Best Buy and go claim your money. Remember, it's not a valid transaction. See, let me give you this example. If you go and you buy, I think we need to kind of clarify this point. If you go and you buy a bottle of wine, God forbid, from the liquor store, okay, so you pay $20 for a bottle of wine. First of all, that's haram, you did a sin. So someone can say, okay, astaghfirullah, I just ask Allah to forgive me for that sin. Is that enough? No. What does Islam tell you? This is not a valid transaction. The money that you gave to the store, go claim it back. It's not a valid transaction. You can't just sit there. Okay. So, or the example of the gold that we gave. the necklace for the necklace. Islam says, no, you can't just keep this necklace. Go back to the store, give it back, take back your necklace, then you could do a separate transaction. It's not yours. This is not yours. Give it back. You're like, well, yeah, but I paid for it through another necklace. Islam says, yeah, that was riba, haram. So it's not a valid transaction. So this necklace is not yours. It still belongs to the jewelry shop owner. Okay. So when you bought this laptop from Best Buy, if the transaction was a valid transaction, the laptop's yours. Even if it gets destroyed, okay, who cares? It's your loss. You don't have to compensate anyone anything. But now that you discovered the transaction is not valid, it's invalid. It's not a valid transaction. That means who still owns the laptop? Best Buy. And the $1,000 that you gave it to them, who still owns that $1,000? You. Give them back the laptop. Get back your money. Sah? Isn't that what it means when a transaction is not valid Islamically? Okay. Now you lost the laptop, it's destroyed. So you go back to Best Buy and tell them, here, I got you another laptop. Ma'alesh, it's okay. Just buy another laptop, give it to them. You guys gave me what's it common? A Dell or HP or Surface Book or Mac Pro with X specifications, brand new. Here, I'll give this brand new laptop, I'll replace it, give me back my money. Can you do that? Yes. Best Buy can tell you, wait a minute, that's not enough for you just to give me the same exact laptop. There's something else that I need for these 3 days. What is it? Yeah. Best Buy can tell you, I'm still the owner of that laptop that got destroyed in your hands. So it was in your possession, and the value of this laptop per day, if you wanted to rent it or use it, is $5. 3 days, $15. Give me $15 too. Because you use my laptop for 3 days. So I'll charge you for the usage of it. You see the idea here? So not only do you have to give them back the laptop or the value of the laptop, you have to compensate them if there's a manfa'a. If that product has a usage in society, you have to give it to them. Another example is a house. You rent a house, you discover that it's not valid. It's not a valid rent, but you stayed in the house for a week. So what do you have to give the owner of the house? A week's worth of rent. Sah? Does this make more? I think with the laptop I kind of confused you. Does the house make more sense? You go to the real estate, you find an owner a tenant, no, not a tenant, landlord, who's renting his house on the market. You see the house, okay, let's decide on this rent. Now, one of the Islamic requirements for a valid rent is what? To specify the two things. What do you have to specify when you rent? Price and duration. Okay, $1,000 per what? Per week, per month? You have to specify. Let's say you go and you rent, but you don't specify the price. And then you go and you move into the house, thinking that later you'll settle on a price. Nittafit, as they say. It's okay. We'll work it out. Ibn Ammi, I'll work it out with him. Does Islam allow such rent? No, invalid. Why? Why is it not valid? The price has not been agreed upon. You have to specify the price. You can't enter a rental contract with no price mentioned in the contract. You can't do that. It's not an Islamic transaction. So you're sitting one whole week in that house to discover, your scholar tells you, look, this is not a valid rental. So you go to your cousin or your brother or whoever it is and tell him, hey, let's do this over. He can say, you sat in my house for a week. Give me what? Give me the money for that week. What's the market value of this house for a week? Give it to me. See? Not only did you have to give the house back to him, but you also had to compensate him for what? The manfa'a, the usage of the house. So that's what the author says on page 15. Now, if you're interested in knowing why you also have to compensate the manfa'ah, the author explains that on page 51. It's a little bit technical, especially the hadith that the Prophet mentions over here that the author cites, so I will not get into that. You don't need to know it for the purpose of this course. But if you'd like to do your own reading and you're fluent in Arabic, feel free to examine page 51. The author tells us why. Yes, I'll just mention something to you interesting about the hadith and we'll conclude. If you got a product and it turned out defective, so you go back and return it, do you have to also be liable for the usage of it during that week? No. I'll give you an example. You got a car, you rented a car. No, let's not talk about rent to confuse you. You bought a car. You bought a car from a car dealership on the condition that the car is what? New, functional, working perfectly. That's a condition in the bay'. You go home and then you bring your neighbor, he's a mechanic, he looks at it, he's like, what did you buy? This piece of car is rubbish. The whole engine is in a meltdown. It's defective. This is a defective car. Go take it back. So the car has been in your possession for about a week now until you discovered this defect. After a week, you go back to the car dealership. He says, okay, let's undo the sale. Because I bought this car on the condition that it is functional, but now it's defective. So here, take back your car, give me back the money. What if the owner of the car dealership says, yeah, but you took my car for a week. Give me an extra $200. I'll charge you like, I don't know, $20, $30 per day. You use the car. It was in your possession. I could have rented it. I could have used it myself. So I want you to also compensate me, not just undo the transaction, but also pay me for that 1 week. Do you have to pay him for that 1 week? No. Why? Because the liability is your fault. You, the car dealership owner, you're the one who gave me a defective product. It's not my fault, it's your fault. We have a hadith from the Prophet about that. And the author has a discussion on this hadith. I'll tell him, no, I'm not going to compensate you anything because it's not my loss. You're the one who caused this scenario by giving me a defective product. So in that case, you're not liable. Any questions on that?
But then what if the car dealer is like, if you don't give me the 200 for the week that you kept, so I won't give you 1,000 back?
Well, he's doing haram. He's keeping...
Then, like, what if he's not a Muslim or he doesn't...
We're talking about Islamic law. Now, if the person has a different civil law, well, there's nothing you can do about that. But we're talking about if Muslims are involved and they're doing a transaction, they have to honor this.
But then can you agree at that moment so you can get...
Yeah, of course. You can agree to claim back your haqq.
Yeah.
But remember, that $200 that he took from you, in God's law, it's haram money.
Yeah.
Now, the person can be non-Muslim and they don't care about these laws. Well, there's nothing you can do about that. Definitely go claim your money, obviously. But in addition to that, you owe the person another $200. In reality, you owe him that money.
Yeah.
On the Day of Judgment, God can hold him accountable. And if he says, well, Ya Allah, I wasn't Muslim, I didn't know these laws. Allah told him, why don't you become a Muslim to learn? No, we have a hadith about that. Yes. Allah will hold them accountable. Why don't you learn my laws? You guys observe your own man-made laws. I have God divine laws. Why didn't you honor them? You have to honor these laws. So yeah, of course, in that case, you can just pay the $200 to get back your $20,000. You don't want to lose your money. But if that person was a Muslim, it's haram money. They're not allowed to charge you that $200 because it's a defective product. It's not your fault. So you don't have to be liable for those 7 days either. It's his loss. Any questions? Is the fiqh of transactions detailed? Remember, this is the tip of the iceberg. وصلى الله على سيدنا محمد وآله الطاهرين اللهم صل على محمد Any question from